This mix deals with the time limitations on discovering certain types of damage and the damages awarded, the different types of damage that can be awarded. So in general, limitations on liability consist of 2 years from the time when the issue is discovered. Now, this isn't the 2 years from the time when it was committed. It's 2 years from the time at which it was discovered or reasonably discoverable or should have been discovered. And there's an absolute limitation of 15 years. That's 15 years from the time when it was committed in practice. There are some exceptions to this. If the injury occurs to a minor and they're not in a position to pursue the case until they reach the age of majority, that 15-year limit doesn't apply. If the person injured was incapacitated, either as a result or not of the injury, if they were unable to come forward, then the 15-year limit doesn't apply. And equally, if the injury was a result of something that was willfully concealed from the people being injured, in other words, discovery was not reasonably possible, then the 15-year limit doesn't apply. When thinking about damages in legal cases, typically in cases of tort, the court is basically trying to compensate for the injuries or losses that occurred, whereas in the case of contract breach, the court is typically trying to compensate for the losses that would have resulted from the fact that the contract wasn't completed. In addition to any direct damages that might flow from this, there are consequential damages which may arise. These are things that result from, but are not caused directly by, the wrongdoing. So, for example, in a breach of contract, there are direct damages resulting from failure to complete the contract, but there may be consequential damages that flow from this. For example, loss of business because of an expectation that the contract would have been completed and the service or good would have been available. In a tort case, consequential damages might be, for example, the fact that a plaintiff was unable to work as a result of direct injury. The inability to work was not the direct cause of the wrongdoing, but was a consequence. In the case of damages that are not easily assessed, for example, non-monetary ones, pain and suffering, these are referred to as general damages. There are limits established for general damages by the Supreme Court of Canada, and courts will typically look at all the factors relevant to those general damages and try to set a value appropriate for the case. In addition to the previous types of damage, there may be punitive damages. These are intended to deter somebody else from committing the same type of wrongdoing, or to penalize the defendant for a particularly bad wrongful act. Similar to punitive damages might be aggravated damages. This is where if the injury caused was extreme or was made worse by the actions of the defendant, then the injury could be considered aggravated and a higher level of damage award would be given. There are cases where the intent is not to recover costs but to prove a principle. And so in these cases, a court may decide to issue nominal damages. Nominal damages means basically there is a symbolic damage applied to prove that a right has been violated, but the intention isn't to try and get money as much or other value as much as it is to prove that that right still exists.